Hey, it's Ben. Rahul and I started this podcast because we love hanging out with fellow trial lawyers and sharing ideas that can make us all better. And both of our firms also regularly collaborate with other lawyers across the countries in cases where we can add value. If you're interested in collaboration, or even if you just have a case or an idea that you want to bounce off us or brainstorm, Rahul and I are going to be hosting confidential case workshops the first Wednesday of each month. So here's how it works. If you have a case or an idea that you want to talk about or brainstorm with us, just send me an email to ben@elevate.net, ELAWVATE.net, or go online to elevate.net and submit a case workshop request. We will schedule you for a confidential 30-minute Zoom meeting where we can talk about your case to see if we can help. If you feel like there would be good value in collaborating on the case further, we can talk about that. If not, that's okay too. We enjoy helping other trial lawyers because we know someday you'd be willing to do the same for us if we needed your help. So again, if you're interested in workshopping your case with us, just send an email to ben@elevate.net or fill out a case workshop request at elevate.net. And Rahul and I will look forward to chatting with you soon. This episode of the Elevate podcast is brought to you by FileVine. FileVine has a software program called Lead Docket, which is the gold standard for managing your new case intakes and leads, your Glenn Gary leads, your Glenn Ross leads, and all of your other leads. So check them out at FileVine and manage your leads. We're also brought to you by Steno. Rahul, you guys work with Steno?
Steno is the best in court reporting services, not just in court reporting services, but even some of their technology tools. We're talking about AI a little bit on this podcast, and their transcript genius, where they can summarize and take interrogatories based on deposition transcripts, is so useful. If you haven't tried it, definitely try it.
We're brought to you by Hype Legal. Hype Legal does digital marketing, web development for trial firms. It's owned by our good friends Micah and Tyler. They recently redeveloped our firm's website, so you can check our website out. If you like it, give them a call, and they can help you out too. And finally, we're brought to you by Expert Institute. Rahul, you guys work with them, right?
We both use Expert Institute because you always need to be cutting edge in the experts that we use in our cases. Going to the repeat experts every single time is going to make you a lesser lawyer, and you always want to keep up, and the best way to do that is with Expert Institute. Welcome to the Elevate podcast. I'm Rahul Ravipudi, and normally I have my co-host Ben Gideon with me, but he is unavailable today. And we usually start with some mindless banter, and it would go something like this. Hey, Rahul, how's it going? Congrats on the Bills continuing in the playoffs. And I'd say, Ben, I really hope the Patriots lose pretty soon because I'm not rooting for them at all. And our holidays were amazing. And let's talk to our amazing guest. One of the things Ben and I often talk about is the inner circle and what an amazing group of plaintiff trial lawyers exists there. I want to talk about another organization. It's the South Asian Bar Association, and the amazing group of lawyers that are part of that organization. And one of them that I had the privilege of getting to meet, become friends with, speak on a panel with is Neel Chatterjee. And Neel, thank you for joining us today, or joining me.
Yeah, thanks for having me, Rahul. It's an honor to be here.
The things that you've done. Okay, so here's a couple of fun facts that I always love to bring up, and I know you love to bring up because it's on your business card that you're the best looking litigator and partner on the planet. Is that the title on your card still?
No, the title on my card, it's close. I wouldn't be that egotistical, right? I mean, it says partner and very handsome man.
I love that. I love that. So why don't you first walk us through your journey? You're a big firm lawyer, you're an IP litigator, and run the IP practice or co-chair of it for King and Spalding now. But kind of walk us through your journey. And a couple of the questions I have that I hope you can address are, how did you continue to enjoy big log practice? How did you continue to maintain that amazing level of confidence that you have, and being at least perceived as a true extrovert? And then we'll move on from there.
Yeah, great, Rahul. So I am a Silicon Valley kid. You know, I often tell people this. My dad literally came to the United States on a boat. He came on a boat into the port of San Francisco. and took a cab to Berkeley to go to graduate school. I grew up here. I was very involved in public service. A lot of lawyers did speech and debate. I did speech and debate, and in my parents' house, they have like, parents have like the Wall of Fame, like, and there is one tiny trophy on there that is like the Western Regional Speech and Debate Tournament where I came in like third place. And that's the sum total of the Wall of Fame of my speech and debate experience. I went to Dartmouth undergrad, and when I went there, my dad was very upset because he said they didn't do real science. And I said, well, the president of the university created the computer language BASIC. I don't remember exactly what his reaction was, but it was something to the effect of, you mean you're trying to be proud of the fact that your school created programming for stupid people? When I was at Dartmouth, I ran a radio station. Dartmouth had a commercial radio station, and we returned money to the university every year. We were number one in northern New England, which probably meant we had a listenership of 7 people. I did morning DJing. I was a morning DJ for 3 years, and I had the number one morning show. When I was running the radio station, we got into a legal dispute with the music royalty companies, ASCAP and BMI. We had to hire lawyers. We had to work with, the university or the college and try and figure out how to deal with this. And, it was expensive. It was time consuming. And I felt like everyone was talking about these concepts that, a dumbass college kid didn't understand. And I wasn't given practical advice. And so I ultimately just kind of made my own decisions about how to deal with it. And I got ASCAP and BMI to walk away from the dispute.
What was the practical advice that you felt like you were missing?
Well, the practical advice was that what ASCAP and BMI did at the time, I don't know if they still do this, is they would go around to lots of little storefront owners, people that were basically living in their restaurants or their little stores. And if you had a stereo in the store, they would come and say, you have to pay a music licensing fee to us for these small business people that are, just trying to make ends meet. We were a radio station, so we were commercial, but we were paying our fees. What they wanted us to pay for was when we played Casey Kasem's Top 10, you might remember that, you would get a record and you would play it, and they had advertising on it. They'd give it to you for free, but they'd take away your advertising. So you effectively were losing money on it, but people liked it, and it was a good thing to do on Sunday mornings when students were too hungover to come and be on radio. And they wanted us to pay a royalty for Casey Kasem or Westwood One Radio Network, whatever they were. I said, well, did those guys pay you a royalty? And they said, yeah. And I said, well, why do I have to do it? Because the only reason these things exist is to go on the air. And ultimately, the practical advice was, as a media outlet, we could go public and talk about what ASCAP and BMI was doing. They didn't like that. It made them look really bad. And practical advice is, okay, there's all, the legal advice is there's all these difficult things, a concept called copyright exhaustion, so on and so forth. Practical advice is call their bluff, use the currency you have to negotiate back. And they walked away from the dispute. And so when I was dealing with that and dealing with the number of the issues of the radio station, I was kind of confronted with the question of, I couldn't get a job at the time. It was a pretty tough job market. My job opportunities were to be a morning DJ at some small market, or to continue schooling. And so I applied to law school, and I got into Vanderbilt Law School. And I thought at the time that was pretty cool because, I had done this little foray into copyright stuff. And I was like, oh, it's in, Nashville, it's the center of country music. And so maybe I could, do some copyright stuff there. I don't know what it was like for you in law school. But for me in law school, things changed very quickly from I want to do this specific thing to I need a job, so I'll just tell people I want to do everything.
Yep. That was the time.
Yeah. I went to something called the Southeastern Minority Job Fair in Atlanta in my second year of law school. I tell people I sent 882 resumes. I got 11 interviews, and I got 2 job offers. One was in Tupelo, Mississippi, and one was in Denver, Colorado. One was a larger firm, but a small office. That was in Tupelo. And then the other one was a 30-person law firm in Denver.
Which one did you pick?
Well, so I went to Tupelo for 3 weeks. I split my summer. I went for 3 weeks. It was a great experience, but I don't need to go to Tupelo again. And then the Denver, Colorado one, when I went, they said right when I started that the firm was going to close at the end of the summer.
Oh, my goodness.
And so we had to, as we all kind of rely on our 2L summer for a job, that was a real problem. And so I started looking at that time, I now had a geographical tie to Colorado, which I did not have before. Coming to the Bay Area is a really tough competitive market, particularly from the East Coast. And I decided I'm going to apply for state court clerkships because at the time they weren't as competitive. And I thought, that might be something I could do or it'd be a little more unusual. And I was hired by Justice Mary Malarkey, who at the time was the junior justice on the court. Ultimately, she became the chief justice of the Colorado Supreme Court. And I worked for her for a year. The very first case I had to work on was a case called Evans v. Romer, which went to the Supreme Court. And it was about a law that was basically an anti-gay law. So that was kind of a big deal. And it was a privilege to work on that. After my year there, I kind of wanted to come back to the Bay Area. And a judge that I knew, her law clerk, had suddenly quit. And it just happened to be when my clerkship was ending. And she called me and she said, do you want to come and work for me? It was a federal magistrate. Again, kind of like those were not as competitive, although nowadays they're very competitive. And so I packed up my truck and I came back to California. And the deal she gave to me was, because, I was not a rocket scientist law student, you have to commit to work for me for 2 years. But if I don't like you, I can fire you after 6 months. It ended up being a great experience. I clerked for 3 years, which was a little unusual. And what the advantage of working in San Jose federal court at the time was every tech company was in there, about every federal court type of legal issue. So I got a lot of exposure to all the different areas of practice. At the same time, I actually wrote one of the very first law review articles on copyright for the internet, before Napster, before any of that stuff. As my clerkship was coming to a close and I had gotten familiar with law firms, I interviewed with a couple law firms, and Oric, which was the firm I joined, in the heat of the dot-com boom, opened up a Silicon Valley office for litigation instead of corporate, which is very counterintuitive. Most firms were opening corporate practices and, getting gobs of money over things like, pets.com or, all right, different kinds of companies. And I was really lucky because people didn't really want to be litigators. They don't want to be corporate lawyers. And I joined Oric's office. It was a fledgling office, but with incredibly good mentors. That's really how I started doing hardcore IP litigation, was working with them. And because it was a small office, we really got incredibly good experience because, it was a small place where they gave us a lot of responsibility.
Especially during that time period. Who were some of your clients?
Yeah, so I'll tell one story about that was pretty incredible. So pretty quickly after I joined, I don't remember the exact year, we were asked to go down to a meeting in Campbell, California, which is in the South Bay of the Bay Area. A little bit of an unusual place for tech companies. And we go down there and we go to the second floor of a building, and half the floor was the tech company. And then they had a conference room, and I think they shared it with another business. They were tiny. It was eBay. And eBay at the time had 1.5 lawyers. They had a guy who had worked for 3 or 4 years in a law firm and gone in-house, and then a guy who was in law school.
Wow.
I remember we were sitting in this conference room and we're talking to them about our capabilities, and they're saying, yeah, we got this huge problem because, we have hundreds of thousands of postings, and then it became millions, and then it became tens of millions. And we just don't know what people are selling, but we know people are going to try and sell everything if this thing really takes off. And as we're sitting there, this guy walks in, and he looked like a Canadian Mountie, like the big brimmed hat, and or maybe a Boy Scout, I don't know, one or the other. And he hands the lawyer this document, and the guy looks around. And he's like, "Someone's trying to sell a duck on eBay. Do you guys know if we can sell a duck?" and so, at that point in time, I represented a ton of companies that were doing all sorts of interesting internet stuff, where today the rules are well defined, but back then nobody really knew what you could or couldn't do.
Right.
I represented eBay when LinkedIn started. I represented LinkedIn when Meta started, Facebook started. I represented them. I represented Microsoft on a lot of significant things. I did a lot of semiconductor work for about 15 years. I was kind of one of the outside core IP litigation counsel for NVIDIA, which is a company that's hotter than anything now.
Yeah.
One of my favorite companies was Logitech. I represented them. I still represent them today on certain things.
Are you on a Logitech camera right now?
No, I actually have a Logitech keyboard and mouse, but I'm using my iPad today. I represented Apple on a bunch of things. And so, like, I've been pretty lucky to be able to represent kind of some of the coolest technology companies in the Bay Area.
And so, as you were working at Oric and starting to build that practice, it almost part of it seems like perfect timing given sort of the fledgling nature of all of those companies and then you building up the Oric IP litigation practice. How big did you grow it before you left?
I think this is kind of interesting because I really felt like when I joined Oric, we were kind of, and I don't mean this in a negative way, we were kind of IP litigation ambulance chasers. We would
I don't know how
often,
to interpret that in a positive way, but I'm
well,
trying.
because I'm
I'm
proud of
just kidding. I'm
because I'm
kidding.
proud of it. We would study new complaint reports and we would literally look for companies that we'd never heard of because we thought those were the most likely to hire us. And we had a couple good clients like Applied Materials and AMD, some bigger companies, but pretty much we were not known at all. And we went from that were, maybe not more than a dozen lawyers that were completely unknown to when I ran the IP group, maybe 12 years later, we were the American Lawyer IP Litigation Group of the Year. And we grew nationally. We acquired a big chunk of a California law firm. We brought on a lot of lateral partners in New York. We built out an appellate team. It became a very, very successful group. I want to say at its peak, it was probably 125 lawyers, something like that.
From your personal vantage point, how did you evolve from, you know, the scrappy reaching out to each individual potential party in a case when lawsuits are filed to then starting to grow into trying a bunch of these cases and then growing into managing 125 lawyers? How does that even work? And then how did you evolve?
Yeah, luck is a big piece of it. Like one of the great things about Oric for quite a while was we did not saddle ourselves with process. Even though I say this to people all the time, like I couldn't get a job out of law school. I was not a great student. I wasn't a bad student, but I wasn't a great student. I'd never met an Indian lawyer before I became one. I always walk into the job appreciative of the opportunity that this gives us. I think it's a real privilege to do what we do. And I really tried to create that ethos within our group, that we should appreciate the opportunity to do what we do. And it's okay to be a little bit scrappy and have your own voice and to approach things with authenticity. And that was a very, in big law, that's kind of a unique thing in some ways. Because there's plenty of people that all read and write from the same script. And I never knew what that script was. So I made it up as I went along. The managing thing was, it was a little bit difficult because I was young and there are a lot of people older than me that, the firm was asking me to manage and not everybody liked it. But the staying scrappy, traveling all the time to, have close touch points with people and really spending a lot of time on marketing and brand development where we would really proudly talk about our achievements internally and externally. And big law then is very different than big law now because big law then was, not a 1,500 person law firm. It was maybe, 700. Now you go to these partner meetings, and I mean, there's so many faces you don't recognize.
Give me a couple of other examples of how big law has changed from your perspective versus how it was.
I would say that, first of all, the advent of legal operations with large corporate clients, they now have entire staffs that are dedicated towards legal operations that aren't actually like the lawyers. Sometimes they are lawyers, but they're really focused on the operations. You even deal with procurement, which are the companies, people who buy things that are like widgets for their company. There's a lot more formality on how you run things. I also think back then when I first became partner, it was like 2000, 2001. People would sit around in a room together a lot and talk about what do we want to do. At Oric, we would have a partner meeting once a month and we'd have dinner and there'd be an office leader or, group leader or whatever. But then we would talk as a group. What do we want to do? That is much, much smaller, the ability to do that. I mean, law firms are businesses. Big laws are more businesses than they are professional associations. A point I made to somebody relatively recently was the two biggest law firms in the country have something on the order of 350, 400 equity partners. Essentially, that means that the average equity ownership is 0.3%. Do people really think a partner there would have a say in anything that the law firm's doing at 0.3% ownership? That's a business. It's not partnership in the way that we thought of it before.
And then do you see partnerships at Big Law now being like each equity partner is its own mini firm within the practice? Is there a competitive nature among the partners, or is there still a collaborative environment among those equity partners?
Yeah, I don't think there's a universal truth on this. There's certainly firms where there's silos and it's basically a bunch of many firms in a big firm. The three firms I've worked in, I did not necessarily find it that way. In fact, if you go to a lot of the big law partner meetings, there's a big emphasis put on collaboration and cross pollination across practices. Because what the goal of a lot of the big law is to expand relationships beyond one particular area. And that's kind of a necessity because of the way conflicts work, right?
Yep.
But, there's always, ambitious people who, we're all type A's, right? Who are all kind of chasing after some of the same clients. And you have to make sure you're coordinating to work hard to make sure people are being collaborative along the way.
Yeah. Okay. So I have a question on litigating from the big firm perspective. A lot of our listeners are trial lawyers across the country, and a lot of our listeners are plaintiff trial lawyers. And, the practice on a single event plaintiff case is a little different than probably the big firm perspective in working up a case for trial for a host of reasons. But I think there's a lot that can be learned from the big firm practice. Can you give us an example of sort of the different pathways and workflows that build up to one of your IP trials, and maybe on a real life example of a fun case you tried?
Yeah. The buildup is, there's a saying that I have in IP disputes, is that when I walk into court, I represent the inventor. Doesn't matter. And then I'd say, what side of the courtroom am I on today? Because in patent law, it's a strict liability thing, and it's a very inaccessible thing to lay people most of the time. All the legal concepts are things you might argue about in court, summary judgment and the like. But the minute you're walking into a jury trial, you have to figure out how to put a story around it, right? It's not, I've tried other kinds of cases that are not, IP per se. There'll be contract disputes or even environmental cases and corporate fraud cases. And all of them kind of operate the same. You start with, this is a case about. And if you can't state what the case is about in 4 or 5 sentences, then you got a real problem. Powerful graphics. When you're talking about technical concepts that are really, really difficult for people to understand, having really powerful graphics to kind of explain the key points that you're trying to put together and using them throughout the trial. So people will see it at the beginning of the trial in an opening. Witnesses will use components of it during the trial, and then you'll be able to use a big chunk of it in closing is important. I have a memo that I wrote on how to prepare for trial, because in big law, sometimes you have very large teams. The junior lawyers won't even know where to sit. And so just a lot of the practical things about how do you deal with stuff, the fact that the jury's watching you at all times, that they have nicknames for you. It's just like what you do, Rahul, but it's in a slightly different context. The big evolution point for me was, in patent cases, you will have these really, really incredible experts. Like, we can hire the world's greatest people. And there were 2 things about experts that I've learned that I think are probably a little different than what a lot of people deal with in other contexts. One of them is, I have the opportunity to hire the best people in the world, but they may not be the best witnesses. So even if they have, at some point, when someone has credentials, any more credentials are not that relevant to a juror. It's just kind of glossy. And so having an expert who is much more people friendly, much more plain speaking, but has enough credentials to be credible is really, really important. I used to get the world's greatest thing. Now I go for a person who is a solid performer, but is also very accessible to lay people, charismatic. The other evolution was, people have a tendency in IP disputes to engage in a technical cross-examination of witnesses. I will never win a technical argument with, God's gift to whatever, semiconductor physics. And so I really believe now that you go after the low-hanging fruit. And that leads me to the story. So I represented this company called Ruckus Wireless. Great company. They do wireless access points. Basically, your Wi-Fi router has an antenna in it that picks up your signal, and they had some groundbreaking antenna related technology that let basically Wi-Fi in your house work faster. I was brought into the case 6 weeks before trial, so I was saddled with whatever the sins of the past were for another lawyer, and I had to stitch together the case. And the other side had some very highly qualified experts, and they had accused virtually every product in the company of infringing, and there was a risk that there would be an injunction that the company could be put out. Imagine being the general counsel and saying, you know what, I want to get a new lawyer 6 weeks before trial on my existential dispute. I just had this strong suspicion about one thing that the expert did wrong. And the case was about antennas. That'll be important in a minute. And so I'm cross-examining the expert, and I put up the patent claim, and I said, okay, let's not worry about all the technical mumbo jumbo here. Would you at least agree with me that to infringe this patent, you have to have an antenna in it? And he says, yeah, you have to have an antenna in it. That's what we're accusing of infringement. And I said, did you ever look at the devices that you're accusing of infringement? And he's like, no, I didn't need to. And that was the risk I took. I didn't know whether he had looked at them or not. He's like, do you ever look at the devices? And he says, no, I didn't need to. I had all the technical documentation. I had this, I had that. He said, oh. And so I unscrewed one of the access points and I handed it to him. I said, can you show the jury where the antenna is? And he couldn't do it. And that's like low hanging fruit, right? Like, I mean, he took the
Oh,
risk.
that's amazing. Well, so what if he said, yeah, I had looked at one of them? How is that going to play out?
Because he had done like a garbage dump of every product we sold, and there were 3 products that didn't have an antenna, and one of the ones I gave him was one that did.
Love it. I love it.
In that case, that was one. The second one was I had a really, really difficult inventor. He was angry about the case. He had had a hard life before he came in. And I made him come to trial, and I made him sit through trial. He'd never worn a suit before. He's a very tall guy, shows up in his 3-piece suit. He has long hair, and he slicks it back. Kind of looked like a mafia guy. I had to work really hard. I had to socialize to the jury that, you know, he had had a hard life. His dad had been killed. He was a Russian Jewish immigrant, fled Russia to come here, and he got into Stanford, couldn't go to Stanford because he had to take care of his mom. And he may not always be happy to be in a courtroom. And I had him at the end of his direct. I asked him, are you proud of what you did? He gave this story where he tells his whole family story. And he says, and then to make something that people actually want to buy and to be acknowledged by the US government in the patents that I created. He's like, this is the American dream. And you can see like all of these people, you know, kind of tearing up. And so between the guy who hadn't looked at the device and my guy telling his personal story and bringing humanity into a patent case, you know, I really don't think anything about the merits was determinative. I think it was the narrative.
That's amazing. That really kind of hits the point of trying to make points with the jury that actually resonate, as opposed to talking over their heads and maybe you score a technical point here or there, but nobody knows you did.
Nobody knows you did. I mean, like, I guess that's another evolution point on the expert side is, I mean, you always want to try and get jurors to understand whatever it is you're talking about. But I really think the juror's role is to assess credibility. It's not necessarily to understand things at the PhD level. And that is really important because people are good at, you know, assessing credibility. Is someone squirming in their seat? Are they kind of just, you know, hired?
Yep. So now let's talk about a couple of other things. I just want to really make sure we cover this because it's really hit me hard and I was so impressed and really why I wanted to have you on the podcast, Neel. So at some point, Trump becomes president and then he issues an executive order with respect to certain law firms saying, hey, the government can't contract with these people or things to that effect. And I know that created a lot of issues for the big firms and how they were going to react to it. And it probably created some disconnect or conflicts with the partners within these firms. Then you created an organization. And because I think it's incredibly brave. And I think now, as we're talking about your background and kind of cutting against the grain and everything that you've done to be a successful lawyer and building a successful practice, totally is in line with it. But can you explain to our listeners what happened and then what you did and what it means?
Yeah. So when the executive orders came out against the law firms, there was also a co-pending thing where there were a bunch of letters sent to about 32 law firms about their diversity and inclusion practices. And I'm very passionate about diversity and inclusion. I've always done a lot of things. I founded the Bay Area Diversity Career Fair, which has now been renamed. Been going for 25 years. Most successful 2L job fair in the country. There was just a lot of hand-wringing in law firms. It was hard to make decisions. There was Munger, Tolles, and Olson had written a really outstanding brief that was going to be an amicus brief in support of the law firms that were attacked. And they tried to get Big Law to sign up. I think less than 10% of the MLaw 200 firms signed on to that brief. And it created a lot of issues. I looked at it as businesses have to do what they have to do. If people need access to government and they're afraid that they can't get access to government and they don't want to make waves, they're going to have to decide that. But there was this awkward thing where there were partners and associates that really wanted something to be said and done, were kind of holding partners accountable. Clients were upset about it. And there was not necessarily a lot of dialogue because as I talked to my colleagues, law firms kind of did what we would sometimes advise our clients to do, which is don't talk about stuff, make some decisions, and move forward. And in a professional services organization, that doesn't work as well, right? Because people want to be able to have a conversation about this. And so I decided, it was a Sunday morning during March Madness. I said, I want to have a space for people to be able to talk about these things. So I created a private LinkedIn group that was called Law Firm Partners United. And I just kind of wrote something. I said less than 10% have done this. I'd like to get some people together and we can just talk about this and then see if there's something we can do in our individual capacities, not in our law firm capacities. And oh my goodness, it took off like wildfire. People say things like you said, Rahul, brave, all of these things. I just formed a LinkedIn group, and then people saw value in it. And within a day, we had 125 people. Within 2 days, we had 250. And today we have almost 900 within 2 weeks. So I was like, okay, now I have all these people joined. People were talking about how do we talk internally? How do we raise these issues in the firm, seeking mentorship and the like. But I felt this enormous sense of responsibility to the group because so many people had joined. It got all this press and stuff. So I went on there. I said, is anyone a nonprofit lawyer here? And 5 of the people in our group raised their hands. And I got them together on a phone call and I said, what is this? Is it a 501c3? What is it? And they said, well, we think we ultimately concluded we are a professional association, kind of like American Bar Association. Okay, great. And within 2 weeks, we had formed an entity, appointed a board, hired pro bono counsel, written a brief. We had town hall meetings among all of the members who wanted to participate. And we filed our first brief 2 weeks after we filed.
And what was that first brief?
I think it was in the Sussman Godfrey case, but it was an amicus brief. And we've now done 5 of them. We'll do more on the appellate side. And I have to say, one of the most inspiring things I've done in my career were those town hall meetings. Because basically, we had a brief drafted. It was all privileged. I got people together. And we just said, okay, we're going to walk through everyone on the call and just say what you want about the brief. And it was very clear to me there were very wildly different political perspectives. There were corporate lawyers, tax lawyers, litigators that all had a view. And to hear people respectfully share common ground where they did not share common ground on a lot of things was kind of the way I think America should work. It was just so cool to just facilitate that discussion.
How did you harmonize all of the different perspectives?
I got to tell you, so we hired a firm in Denver. It's in some ways it's similar to your firm, Rahul, that the Olson Grimsby firm. And Eric Olson, who is the Solicitor General of the state of Colorado, he was experienced in doing this because he led the state's fights against the government when he was the Attorney General. So he was always building consensus among different states with different perspectives for common briefs. And so he just did an amazing job on pulling it together. And it was a non-political brief. It was just the rule of law and the Constitution are important. And, we have some fundamental issues here that are at stake. And so that was, it was really awesome to assemble a team and to kind of, actually get this thing rolling. And actually this, now I just got an email today. I have to file a bunch of, formal nonprofit documents,
So tell us a little bit about the outcomes of the 5 briefs and amicus briefs that you filed so far and where you see this all going.
Yeah, so the law firms that fought the executive orders got a clean sweep. Every single one of them has been, all the executive orders have been found unconstitutional. They're now being appealed. Mark Zaid, who's a pretty well-known guy, he got his security clearances revoked. We've also put an amicus brief in his case, and that case is ongoing. That one's a little bit different, so there's not an outcome yet on that one.
Take your playbook to the next level by joining a legal network of all-stars at psrplaybook.com. psrplaybook.com is a free digital legal library created exclusively for plaintiff lawyers by the nationally recognized personal injury law firm of Panish Shea Ravipudi LLP, and features video content showcasing the tactics, strategies, and concepts implemented by some of the industry's most successful trial attorneys. PSRplaybook.com promotes learning, shared knowledge, collaboration, and best practices. Get in the game and see for yourself by joining our national network of plaintiff lawyers. Subscribe now at PSRplaybook.com and learn from the best.
So one of the things, as a plaintiff trial lawyer, a lot of times we have tort reform and a lot of different industries trying to attack people's access to justice. And then we see a lot of different perspectives as well, where there's a lot of people who, like myself, who I'm just worried about my clients and my potential clients and what the impact of any type of reform, they call it reform, but really I see it as oppression and taking away a Seventh Amendment right to a jury trial, what the impact is on the entire justice system. Now, when these executive orders came out, obviously there were the law firms and the way that they reacted and what you talked about there. But your 900-person group, you talked about ethos in your firm. What's the ethos of that organization?
It's changing, right? Because there was this moment in time, let's say March of last year through June of last year, where people were very, very active. And now there are still people who are active, but it's quieter, right? People kind of think, okay, we've kind of got our process in place. I forgot to mention one thing. One of the really important things that I felt like we did is when we filed the amicus brief, we filed it on behalf of Law Firm Partners United, but we allowed people, we only had a 12-hour window to put their names on the brief. And we had the first brief, we only had about 110. But the second one, we had 250, 300 people put their name on the briefs.
Amazing.
And that was kind of interesting because people said that it meant so much to them to just be able to put their name on a brief supporting the rule of law. And after we filed our first brief, there was another group that was formed called General Counsels United, which is, head lawyers for big companies. And that group has 800 lawyers as members today.
Wow.
So it's pretty cool. Now, let's go back to your question. I forgot what it was.
Yeah, what's the ethos of your organization now? And so what's the mindset on protecting the rule of law, of course, but what's the reason behind wanting to protect the rule of law from the big law perspective?
Yeah, because, we rely on it, right? We rely on it because, Rahul, like you talk about as a plaintiff's lawyer that is, going to court and wants access to courts. But, a lot of these law firms, right, they're much more corporate than they are in court lawyers. One of the things that we've talked about is, should we start public education around what the rule of law means? Because that phrase is a very inaccessible concept to non-lawyers. I think about when we drive down the road, there are little yellow lines that divide us from going one direction or the other, and that keeps us from killing each other, right? And there's some lawyer who developed that rule about which side of the road we drive on, how wide the road's going to be, and how much those little lines have to be spaced. And that's rule of law. It keeps us from killing each other. In corporate deals or in tax or in litigation, if we do not have a system of rules we can live by, there's nothing that's enforceable. There's nothing we can do to operate in our daily lives.
From your perspective, how did the executive order constitute a direct attack on the rule of law?
Yeah, well, basically it said for who you represent, we can preclude your access to government. We can preclude your access to courthouses. We can preclude your access to, even if it's regulatory things like the FTC or the SEC. And, lawyers have to represent people sometimes on unpopular causes, right? When my kids were younger, we would talk a lot about why do I represent prisoners in civil rights cases, right? And attacking law firms for who they represent and just doing their job, it just frustrates the goals and objectives that we have. And, like the fight isn't over, right? I mean, it's not just the attacks on law firms. There's a new rule in place that puts a cap on the amount of loans that students can take to go to law school. I mean, that's a huge deal because that cap on the loans, a lot of people who might come from a first gen background that can't afford law school, that want to become civil rights lawyers, they need to take those loans to go. And, the reality is that, in the nonprofit world, a lot of those folks are first gen lawyers. It's the case. By putting the cap, you're making it harder for those organizations. There's a chilling effect on pro bono work that law firms are willing to do. I mean, it's happening. And so we still have a lot of things on the rule of law being frustrated because people are not as willing to take on these really important battles.
Yeah. At the very beginning of this endeavor, was there a lot of fear of retribution for even joining your association?
Yes. So I won't name any law firm names, but the differences I was surprised by the differences of opinion about how people dealt with it. So I was just like, we're just a bunch of people getting together to talk about stuff. But there were law firms that encouraged people to join. They said, we can't speak ourselves, but we strongly encourage you to. There were law firms that said, you do you. If you're doing something in your individual capacity, we don't care, go do it. And there were law firms there's a way to hide if you're a member or not on LinkedIn, but a lot of people didn't activate that. There were law firms that searched how many people in their firm were members and, would tell them they didn't want them to be part of it. And at times, I mean, I heard rumors that people's careers were threatened.
Unreal. And then what about just fear of retribution directly from the government? Were some people just afraid to join and put their John Hancock on anything because they were afraid the government would directly attack them or their firm?
So that's where my background in social media was really helpful because everything we did was about privacy controls. If people wanted to be public and they wanted to put their name on a brief, they could do that. But if they just wanted to be in a private LinkedIn group and be part of, roughly 900 people, they could do that too and not have their identity known. And they were given the control to do that. They could toggle the button in LinkedIn. They could put their name on a brief or not. They could join a Zoom call or not. And they were given the ability to be as public as they wanted to be. And, when we got all this press, I didn't want it to be just about me. So I put together a comms team where we had a whole bunch of our lawyers that wanted to be public talking about it as spokespeople for our group. I forgot to mention that we also hired a comms company for free. They work for free, Vision 360, that did all of our media relations.
Fantastic.
And they were terrific. They were world class and they dedicated like a lot of people to manage the press and everything.
How much time do you spend on this aspect?
Right now, I don't feel like I'm spending as much time as I would like. I just finished a trial. And so you know what it's like. I mean, trials all consuming. We are now talking about what else can we do? I actually, I need to go back to the group and I have some ideas on things we could do. And some of the other members have come up with ideas and we're going to see if there's some additional things we can do out there. But right now it's not a ton of time. When the next round of appellate briefs come in, that's going to be the more time consuming piece.
What amazes me about this is that really the reality is when you see an attack, there's a way to respond. There's fight or flight. And it's not something where you get compensated for your time. It's just doing something because it's the right thing to do. And that's what really impresses me about what you've done, Neel, and what you've inspired in getting this organization put together and then following through on making things happen. You doing things actually makes a difference. And so for all of our listeners across the country, if you were to give a parting message on their extracurricular activities and the importance of actually doing something, even if you're not getting paid for it, just to do it because it's the right thing? How would you spread that message?
Yeah, so one of our South Asian lawyer friends, Alamdar Hamdani, I saw him speak as must have been 15 years ago, and he was asked a question like that because he was in public service for quite a while, and he said his opening line in his speech was "Do good." It's a privilege for us to do what we do. Like I said, I walk into the door every day and I think I feel lucky to be able to do what I do. Everyone is going to have a different way that they can find meaning and contribution. But everyone can find. And if you can find ways to do things that are big or small, and small is not, it may seem small to you, but it's not to other people, and do good without expectation of anything in return, it rewards you in just, enormous, enormous ways. Like I tell first year lawyers who say, well, what can I do in terms of mentorship? I don't know anything. And I said, well, for a second year law student, you walk with the gods because you have a job and they don't. And if you're a first year law student and you're talking to a senior in college, you walk with the gods because you got into law school and they haven't yet. And there's always an opportunity to do good for just those one or two people, and it'll make an enormous difference in paying off.
I love it. I love it. I really appreciate everything you're doing, Neel, and it's always great to see you. So thanks for making the time to be on here. If anybody has questions or wants to reach out to you, what's the best way to connect with you?
One of two ways. LinkedIn is always great. I'm pretty active on social media, on LinkedIn, a little bit of a box of chocolates. You never know what you're going to get. And then you can always email me at nchatterjee@kslaw.com.
Fantastic. Thank you so much for joining us, Neel. I hope you'll come back, and I want to get an update on all the progress you've made.
Great. Thanks for having me, Rahul.